Good afternoon, everyone. Welcome to the Judicial Proceedings Committee. Today is Wednesday, January 15th, 2025. We have 6 bills on the docket, and first up is Senator Quarterman with Senate Bill 92. I like this bill. We got to figure something out. This is a pretty interesting story here.
Thank you, Mr. Chairman. Vice Chair, members of the Judicial Proceedings Committee, for the record, Senator Paul Quarterman, District 2, representing Washington and Frederick counties. Thank you for the opportunity to present Senate Bill 92, Peace Orders, Intentional Visual Surveillance. So many of you heard this bill, which is a variation of this bill last year. As a refresher, and for some of the new committee members, what this bill does is it authorizes a person to petition for a peace order and to be heard in court on the grounds that the respondent is conducting unwanted visual surveillance of an area of a residence where they have a reasonable expectation of privacy. Additionally, though, what has changed from last year to this year, the bill also expands available relief under the final peace order to include 1, remove or reposition of a device being used for visual surveillance within 15 days after issuance of a final peace order, and 2, refrain from further visual surveillance. If the petitioner meets this burden in court, the judge will then be able to issue an order to the respondent, order them to refrain from committing these acts complained in the petition. So it's important to note the second part, because that was part of the issue that we had last year. The judiciary had raised some concerns that the current statute wouldn't allow a judge to provide that relief. While working with the judiciary during the interim, we also found out that some of the current things already in statute, it didn't provide relief for them as well. So we worked with the judiciary, with Judge Morris, we worked with counsel here on the committee to bring the product that's before you today. Some of you may recall from last year, for new members again, in the spring of 23, our office was contacted by a constituent with concerns regarding a disturbing pattern of behavior being exhibited by their neighbor who had moved in behind them just a few months ago. The neighbor had placed about a dozen plus Ring cameras in a very aggressive manner all along the property line. Some of them pointed directly into their backyard where their 2 minor-age daughters who cared for their farm animals, a place, again, where a reasonable expectation of privacy would exist. And again, we're talking about minor kids in a backyard, away from the property of the neighbor, but directly focused on them. The constituent contacted the sheriff's department. They instructed them to approach the neighbor to inquire, why do you have so many cameras? Why are you watching our children? And the response simply was that he had a right to do so. This behavior continued on for many months, now almost 2 years. The constituent attempted to file a harassment or peace order through the sheriff's department, but then they informed them that current law wouldn't allow them to provide that relief. Given this information, the family attempted to block the neighbor's camera view by installing metal poles and wooden boards. You see some of those in the pictures in front of you. The fence line to the right is the constituent's property line. There's billboards, or not billboards, plywood boards that were put up or to block the cameras, as you see some of them circled that are on trees. And you don't see the house or the home of the neighbor because it's well off to the distance. So again, these cameras are all set up all the way at the very edge of the property line for the direct reason to look into the property here where these children are playing. Very aggressive, very intimidating, and what most reasonable people would think is a violation of their expectation of privacy. I believe there are a couple other photos in there. I don't know if we can switch through any more or not, or is just that one? Do you have any other photos?
Yeah, if you just hit the arrow.
Oh, I can do it. Oh, well, that might be a problem. All right, so this is a good one here. So this is the neighbor here. He's on a ladder, hanging a 2x4 in a tree so that it can overhang and take more pictures. So again, you see all these plywood boards that the constituents had to put up, again, to try to block these cameras looking in. And so cameras, again, all the way around, on trees, all the way up on the property line. So that's the one that was, the gentleman was putting up in the tree, again, so he could look over top of the boards that were put in there. So again, very aggressive, very, very intrusive. So look, we understand property owners have a right to place cameras on a property. At the same time, we believe a family has a reasonable expectation of privacy, and this aggressive and intrusive behavior is unwarranted. We understand there's going to be challenges here. The intent, though, is simply to allow the family to file a peace order so they can get in front of a judge who can very clearly see what is going on here and then adjudicate appropriately. To the point, though, our cross file last year that was heard in judiciary, the subcommittee there felt that that relief could already be found, so they encouraged the constituent to go ahead and file a peace order, which she did. Showed up in court 4 different times. Nothing ever came of it. Things were dropped, and this continues to go on. again, we worked with the judiciary to try to work out some of the issues before. We're obviously not the attorneys. We're welcome to anything that the committee may feel may make it better. We're just trying to find a remedy, because it's not just about this individual here. This is what brought it, but we're seeing this a lot more as we progress with technology and things of that nature. So again, thank you for consideration, and we respectfully ask for a favorable report on Senate Bill 92. And I believe Hannah may be with us.
Excellent. All right, we can go to Hannah, then we'll turn it over to the committee for questions. Mr. Leatherman, welcome.
Thank you. First of all, thanks for allowing me to speak today. My family is in favor of SB 92 going into law because we have been dealing with a neighbor who has intentionally, as Mr. Quarterman said, set up video surveillance near our property now for over 2 years with multiple cameras. After talking to police, we found that there was no recourse against this intrusion. Our neighbor built this house on the property that backs our small barn where our 2 children house our 4-H animals. And shortly after he moved in, he placed 3 cameras in a line of trees about 5 feet off the property line, facing and pointing directly and deliberately towards our barn. He's able to view them and see our children at the barn, as well as possibly hear audio. It was obvious these cameras were placed for the sole reason of surveillancing us. Our children's animals have never gotten out of their fenced-in area or barn, and our children have never gone onto his property either. We confronted our neighbor about the cameras, but he did not give us any assurance that they would be coming down. He actually told us, quote, "because I can," is why he was doing it. My husband and I decided our best course of action was to block the view of the cameras with plywood and screen, like you saw in those pictures. Our neighbor responded by moving the cameras to see around the blockage, forcing us to add more screening and plywood. We felt like he was harassing us and our children, yet there was nothing that we could do to protect our children. We are careful if we send our children to take care of their animals down there and do their barn work. Last year, we also attempted to get a peace order served that we hopefully would force our neighbor to take down the cameras that were intentionally placed to watch our property. After filing the paperwork and 4 weeks of trips into our district courthouse, I was told each time that our neighbor had not been able to be served and that he was most likely avoiding it. An attempt to serve a peace order expires after 30 days, so our efforts were a waste of time and money. In talking with others about our situation, I've been very surprised at the amount of people just in our community that are also dealing with similar situations. These people also found they have no legal recourse. We understand that almost everyone has security cameras these days, and sometimes they see a piece of a neighbor's property. There is a clear difference, however, between using your security cameras and intentionally surveillancing your neighbors. Our story is just one why SB 92 needs to be put into law. Thank you for your time.
Thank you very much, Ms. Leatherman. Senator Quarterman, questions from the committee? Senator Love.
Thank you, Mr. Chair. First of all, I'm sorry for what you were going through. This sounds horrific. And Senator, thank you for bringing this bill. My question is based on what was just said, that there was an attempt to serve a peace order, but they could not serve the individual. How would this bill change that?
So we have 2 things going on here. So the serving issue is kind of a separate thing. So we'll have to work on that regardless of what the outcome of it here is. The subcommittee and judiciary in the House had encouraged you to file the peace order because they thought the relief could be granted. We further found out from the judiciary, even if that individual would have showed up in court, the authority wouldn't be available to begin with. So there's kind of 2 separate things going on there. We'll correct the serving issue with our local state's attorney's office and sheriff's office to make sure this individual does get served. The challenge here is there's nothing in statute that will allow the removal of these cameras. So if we had got him into court, there was no relief that could have been provided.
Got it. Thank you very much.
Of course.
Thank you, Mr. Chair.
Further questions from the committee? All right, seeing none, thank you very much, Senator.
Thank you.
We'll work on this.
Thank you.
All right. With that, that'll conclude the hearing for Senate Bill 92. We'll now move on to Senate Bill 108. Senator Washington, welcome back.
Good afternoon, Mr. Chairman, members of the committee. Great to be here. Great to be back in this, my favorite committee I've ever been on. You know, it's my favorite committee, man. It's not a lie, it's the truth, brother. It's the truth. For the record, Senator Alonzo Washington here to speak on Senate Bill 108. This bill is a really great bill. It requires the governing body of a common ownership community to develop a smoking policy that is at least as stringent as the applicable state and local laws regarding smoking for multifamily dwellings, and that's limited to condos only. Condos only. I know the folks who are in opposition to this bill are going to come up and say, well, what if you lived there for such a long time and they create this policy and whatever have you? Let me make some things clear. This doesn't require them to say that there's no smoking there. This doesn't require them to say there is smoking. That just says that this bill only says that they need to just create a policy on smoking in condo units. Just imagine you owning a home, a condo, you've been there for 20 years, someone comes in there and buys the unit next to you, and that person next to you ends up smoking. And they smoke profusely. They smoke every single day. They smoke every day, and it comes into your home. That could be a nuisance to that person. But there's no law or rules or regulations for relief for that homeowner, for that person that lives there. We're letting that homeowner down by not passing this law, requiring them to create a policy so that there is relief for that homeowner. We're talking about just homeowners, people who purchased their home and been there for years and just want to make sure they can raise their family in those homes. Imagine you're a homeowner, you're a condo homeowner. You just came home with a new baby and you have 3 other little babies with you. But the next door neighbor just purchased their home and they end up smoking there. The smoke gets into the home, then it causes problems with the babies and everyone else that's in that unit. I'm asking this committee to take this bill seriously this year, because I think that this is going to be continuing to be a longstanding issue. The AG supports this bill. The Attorney General supports this bill. They're here to speak on behalf of the bill and legislation because they have no recourse to help in this types of situation. So they're asking for this to solve some of these issues. I know they have examples for that too. And I know you guys have heard this bill multiple times since I've been in the Senate, and even a year before I wasn't in the Senate. But if you pass it this year, I promise I won't come back again with this bill. This bill only. This bill only. And how did Nick Charles get all the way up there, man? That's crazy. No, I'm joking. But with that said, I urge a favorable report on this piece of legislation, and I'll take any questions.
All right, thank you very much, Senator. Questions from the committee, Senator McKay.
Senator, thank you for this bill. Not necessarily agree with it, but your observations are spot on. Thank you.
All right, excellent. Further questions from the committee? All right, I think we have one. You have a witness here is from the Attorney General's office. Yep. She can come on up. Karen, good to see you. Welcome.
Mr. Chair, Mr. Vice Chair, members of the committee, my name is Karen Strawn, and I'm with the Consumer Protection Division of the Office of the Attorney General, and we are here in support of this bill. As the good senator said, we do receive complaints from time to time about individuals who are living in a condominium unit, and the condominium next to them is smoking, and it's carrying over into their unit, and they want to do something to try and protect themselves. And they file a complaint with our office and we mediate, but there's really nothing without some sort of policy, there's really nothing that an association can do to stop that individual. They're in their own house, they're doing what they need to do. So really what this does is it just says make a policy. You can make the policy whatever you want it to be. The policy can say you can smoke on common grounds. The policy can say you can smoke in your unit. The policy can say all kinds of things, but it's to protect against situations where when you're getting ready to move in, so that you as an individual know what you're moving into and you can make a decision based on what makes sense for you. Smoking is deadly. I think we can all agree on that. And as a result, I think it's important that we ask these associations to make some sort of policy so that people know what they're dealing with when they're purchasing a home. And for those reasons, we ask for a favorable report on this bill.
Thank you, Mr. Chairman. So if this passes, what are you going to do with it?
Well,
So I have lived there 20 years. Somebody moves in. The group then decides we want no smoking. I've been there for 20 years. What are you, the consumer protection, going to protect my rights? Because I've been there for 20 years and now the group has decided they don't want to do any. Are you guys going to buy the property?
of course not.
Oh, okay, but you have created a legal, if we pass this, we're now creating another legal wranglement and allowing the AG to be in favor of this. The other question I would have is, I am 100% against smoking marijuana. Recreational, medical, whatever. We went through the process, we've decided that this is what we're gonna do. Is there a difference?
Is there, what do you mean by, is there a
in the
difference?
Smoking of marijuana, and then if there isn't, and I have a medical card, now aren't we gonna be getting into determining if somebody actually has a medical reason for it? And I think you're opening up Pandora's box, and I don't know how we make it pretty. And
Well, these are all considerations that the association gets to make when they're making a determination of what the policy is going to be. And that would require them to meet with the association members and make a determination as to what the group wants. It's, that's one thing that is a little unfortunate about living in a condominium unit, is that sometimes you have to make decisions that are what the group wants and not necessarily what each individual wants.
so I'm being there for 20 years. The group comes in and decides that they don't want to smoke, we have to have a policy, and they decide no smoking. What am I supposed to do with being there for 20 years?
Well, in most cases, the policy is going to consider, first of all, what each person wants. But let's say that you are the one and only person in the unit, one and only person in the association that wants to have smoking allowed. I would think that the association would do some considerations, like making sure there are places of common element areas where you could still smoke, so that you could still be able to do the things that you wanted to do.
Are those protections in this bill?
The bill simply says, make a policy. It doesn't say it has to say anything in particular, other than being at least as stringent as what the state and local laws are.
So there again, why is the AG weighing in on this? Other than I know that we believe that smoking is bad, except if it's marijuana, it's okay.
Because it's something that there are a lot of people that are having problems, because they might live in, just as you're saying, you have an individual who lives there for 20 years and smokes, you might have an individual that lives there for 20 years and doesn't smoke. And that person should have just as much rights as this person who smokes to be able to decide whether they're in a position to be in a place that allows them to keep up what they're hoping to be their environment.
Okay, I go back and it'll be my last. I've lived there for 20 years. What am I supposed to do? Get voted out?
Well, you don't get voted out, but
If you create a no smoking policy, and I've been doing it for 20 years, now I'm violating the policy. Now what is, now that we're giving a legal opportunity for the association to what? Do fines, we're opening up Pandora's box, but thank you.
Thank you.
Yeah, if I could just respond to that, Mr. Chairman. This bill simply says, as the Assistant Attorney General said, it sets a policy. It does not say that they have to be penalties. The penalties can be zero. It doesn't require them to say that they can't smoke or will smoke or they all can smoke. It doesn't say anything like that. The association decides amongst themselves, just like they can decide that they're going to increase the condo association fee by $250 every month because they need to pay for such and such X, Y, and Z either with your vote or without your vote. They can do that. Whether you've been there for 20 years or you've been there for a month, they can vote for those things. Now, I wouldn't support that motion in my condo association for $250 increase, but I support this measure because it's simple. It says create a policy so that you all agree to, and the majority of the community there, according to your bylaws, agree to, and you all have to adhere to this. And because it's a common ownership community, they set their own bylaws and ways that, and rules can be enacted within their association. And so I think this is a simple common sense law and something that this committee should pass.
Thank you, Mr. Chairman. And yes, I remember this bill, Senator Washington. And I can see both sides of this, but I have to drill it down on the, questioning this. So kind of dovetailing to Senator McKay, it is, to me, problematic to retroactively create policies. So there was sort of what the lawyers would call detrimental reliance. You buy a property, you're allowed to do these things. You're a smoker, and let's say. You could also be disabled and have great difficulty going outside. You could also be a young woman who feels extraordinarily unsafe in whatever common areas you might have. So you could potentially put quite a burden on the smoking population. So it's going to be a tough balance. But I'm sort of wondering why there aren't, I appreciate Senator Washington saying, hey, there's no real guardrails in the bill, but that also means there's no limits, which means you could in many ways be quite unreasonable with the smoking population, be it marijuana or cigarettes. And if somebody has a medical reason for smoking marijuana, and now we're treating them differently than someone who has glaucoma or just some other disability that makes it very difficult for them to go outside. Can you kind of address some of those balancing factors and the fact that there are no guardrails or limits in this bill to reasonableness for all people involved?
Well, while in your opinion, there's no guardrails to reasonableness, at the same time, you have people who want to be in a situation where there's no smoking. So what the association needs to do is to weigh the rights and the obligations to the people of the community and to do what the majority wants. That's how condominiums associations work in general, that you're doing what the majority wants. So there are constantly new rules and regulations being made to affect people regardless of how long they've been living there. There are ways to grandfather people in, and they can consider that and consider grandfathering a person in to make sure that they are protected because they've been there a long time. There are lots of ways to do it. It's just going what the majority of the people want.
Well, I guess what I'm struggling with is, for example, how would I phrase this? Give me just a moment. You've got people that bought into the property knowing you could smoke at the time, and you've got other people that are buying into the property knowing smoking is allowed. So I feel like there is some weight to all the people already there not to make anything retroactive. I get sort of prospectively new condominiums coming in and saying, hey, we're going to be a no smoking condominium, that's what, or a common area, whatever the rules are going to be. So there's an inherent unfairness, in my opinion, when you are going inside an individual's private residence. But I do understand, the difference between a home and a condominium, but I'm just struggling with that. The other issue I have is I can also appreciate if someone is smoking a lot, marijuana, tobacco, whatever, and it is getting into the ventilation, if it is, then you get into nuisance laws and things like that, where you already have laws, and processes for remedy. What I'm struggling with again is assuming someone lives in a condominium and takes all the extraordinary efforts to keep the smoke inside their condominium, but another neighbor just simply wants you just not to smoke because there are some very self-righteous non-smokers. Again, how does this bill protect this balance?
Well, I think the bill protects the balance by the mere fact that you can make the policy whatever you want it to be. I think it protects that balance because—
Whatever you want it to be isn't a balance, though.
But it is a balance in that the association, when they're making that determination, can make a determination that says you can smoke anywhere. So that could be the determination that they make. Or they could make a determination that says only new people moving in are the ones that are going to be prevented from smoking. So there is a balance in that the association is actually making the balance itself by making a determination as to what.
So let's say association, last question, is unreasonable. And by unreasonable, I mean they're They're like, I don't care if you're sick, I don't care if you're disabled, I don't care if you have a medical card, and I don't care if there's just one of you and you've done all this stuff. What recourse, and there may be none, but, because I'm not a condominium lawyer, what recourse does the individual, the minority, because, might doesn't make right, right makes right. So I get that condominiums are ruled by majorities, but right is right. So if somebody's just drilling down and the whole group is being terribly unreasonable, is there any recourse in this bill for some review? I guess the answer is probably no, but I'm just curious because I'm not a condominium lawyer.
Do you mean review of the policy that was made?
Yes, especially, if I load it up with lots of unreasonableness that even you all might agree is pretty unreasonable.
Right?
Huh?
There could be a potential lawsuit there, right?
I don't know. I'm not an expert in condominium law. I don't know if there's a reasonableness in condominium umbrella law, legal concepts, if there's an inherent reasonableness that has to occur, or if might makes right in a condominium and anything the majority wants, not just this, but anything, they can do it. So I don't know how that works. So anybody that could address that.
Well, basically, if you were to make this policy, this would fall under your rules and regulations. And the law already has a plan in place for people who disagree with a new rule that was put in place. And it allows them to go to the board and ask for an exception, number one. If they don't grant the exception, it also allows, if the majority of the association feels differently, it allows a process by which you go through and you can overturn the rule that was passed. So there are policies to do that. Again, it would be a situation.
But not an individual's ability. It'd have to be a majority. Again, it might make right a majority.
The individual can do an individual looking for an exception. It would be the majority that would be doing the changing of the rules and regulations.
Thank you, Mr. Chairman.
And can I just say something real quick? The Senator mentioned the nuisance laws. I have not found a place where it has worked. In this situation, for being a nuisance, if the smoke seeps into your home and you try to file a grievance, and there's really no recourse or relief for the homeowner for any situation. Like, that's what we're trying to resolve here. Like, you can go to your condo association right now and say, this neighbor has been smoking and it's interrupting the way I live in this home, and how can you help me? They will say there's nothing. They have said, condo associations across the board, across the state, have said that there's nothing that they can do in regards to smoking.
Well, nuisance laws exist, so I think you're getting misinformation there, and that is also kind of makes the point that condominium associations aren't all that with it if they're telling you there's no remedy for a nuisance. So I'm troubled by that, but that also speaks to this bill and the fact that apparently condominium associations really don't understand what goes on and how the law works. So it's not a good point. Yeah, thanks.
Senator West.
Thank you, Mr. Chair.
I love this bill.
I'm flummoxed by this bill. Right now, these governing bodies of common ownership communities have the right to adopt whatever policies they want. If they want to adopt a policy relating to loud music, they can do it. If they want to adopt a policy relating to unusual pets, they can do that. Unusual smells, they can do that. To the extent they haven't done it, it's because they don't want to do it. So what this bill does is say you must adopt a policy on smoking, and it must be as stringent as the local and state laws. So if they don't want to do it, they'll just say our policy is to adopt the local and state laws, which basically is a non-policy because they already apply. So I'm not sure what this really gets at. If I were on the board, I would say stay as far away from this as you can. You're going to buy yourself nothing but hassles. We've heard some of those hassles rehearsed just here with the interplay between Senator, yes, sorry. And we don't want these kind of hassles, so let's just stay away from it, and we'll say our policy will be the state and local laws, period. That's what I would do. So why are we going to force condominium owners associations to adopt a piece of paper which says we apply the state and local laws? It seems like a hassle and unnecessary.
Well,
go ahead.
It's really allowing people who don't smoke or who don't vape or do marijuana or anything like that, a voice in this matter as well. Because they, as the association and the members of the association, are the ones who are going to be voting to make a determination as to what's going to be done. So it's allowing a voice for everyone.
So what you're going to do is generate an acrimonious meeting of the governing body of each of these organizations to go through all the pros and cons of adopting all kinds of elaborate policies. And in most cases, if they're sensible, they will say, we choose to adopt the policy we have right now, which is no policy on this issue other than whatever the state and local laws is.
Then that's a policy. The policy has been adopted.
Why
Box checked, move on to the next condo
Why should the Maryland
association.
General Assembly force them to go through that exercise?
Because we just legalized marijuana here in the state of Maryland. And we regulated it, and it's legal now, and it has been bothersome to many condo homeowners in this state. And so having an ability for them to have some type of rule within their bylaws that says that either they can or cannot smoke, that goes through that rectifies that argument or that contention between two neighbors, is helpful. If they say smoking is allowed, then smoking is allowed, and then that's the end of it. That's the bottom line. If smoking isn't allowed, then that's another method to resolve that issue. Right now, there's no between neighbor to neighbor disputes within condo associations with regard to smoking. There's nothing in the laws or nothing in the bylaws that prevents that person from encroaching on their quality of life. That who own that property for over 20 years, who's been there, paid their taxes. The state of Maryland is not helping them. The state of Maryland is not helping them. We're leaving. They need help in this situation. And we come here to Annapolis to resolve issues that happen in our communities. This is a significant issue that's happening in my community, where I know these condominium owners really want to make sure they can rectify the situation between neighbor to neighbor.
Okay, thanks.
Actually, I'm really glad my colleague from Baltimore County raised that question, because that's where I was going, but I have a different take on it. And that is that right now, condo associations could make this policy, correct? They could sit down and have these hard discussions, which they already do for so many other things, correct?
Correct.
Okay, so we're not imposing any new, how do I want to phrase this? We're not saying you must outlaw. We're not saying, if we were to pass this, we're not saying you must allow. We're just saying that you already have this authority to do it, and you must do it. Am I reading this bill correctly?
That is correct.
Okay. So my different take from my colleague is that I have condominium associations in my district that desperately want this policy. And there are others who don't want to have this hard conversation because it is hard. And so I think we are actually giving them the support that they need to move forward and have these conversations, as condo associations do on so many other things. I mean, I was just having a conversation with somebody about noise ordinances. I know people who, the harder they concentrate, the louder their music is. I need absolute quiet. Condo associations make those decisions all the time. So my question is, now that I'm in the Senate and I can make these statements, which we never used to do in the House, my question is there anything in this bill that would dictate one way or the other that says you have to allow it, you have to have penalties, or is it just saying you already have this right, now go ahead and exercise it?
That's correct. It says that you have the right to do this. You can do it, have that tough conversation, and move forward with it. You do not have to have any penalties associated with it. You decide where you go. And in this committee, we're assuming the worst, and that folks will outlaw this, but we're giving them the ability to make the decision on their own.
Thank you.
Senator Love, you're correct. In the Senate, we treat people like adults, so that's good.
Terrible.
Further questions from the committee? All right. Thank you both very much. Thank you, Senator.
Thank you.
All right, so that'll conclude the testimony for the proponents of the bill. We now have one witness in opposition of the bill, Mr. Boriano. Welcome.
Good afternoon, Mr. Chairman, members of the committee. For the record, Bruce Bariano, here on behalf of the tobacco wholesalers. Very strong opposition to this bill. I'll try and speak as quickly as possible. I'm sorry I have so much limited time, but I'm very disturbed by this hearing. I really am. First of all, I'm into condo associations, so I'm very familiar with them as a condo owner, both in Crisfield and somewhere else. When you go into a condo, when you buy one, I think it's your obligation to read the condo rules, know what you're getting into. You are going into a combined living arrangement with people that you don't know. That's what condos are all about. You're not in your own apartment, in a rental apartment, and you're not in a private home, and there are responsibilities there. Secondly, I'm very disturbed, very respectfully, that this bill is not being read properly and accurately to the committee. Senator Love, it's a pleasure to see you. The answer you was given, very, very respectfully, is inaccurate. It's not correct. If you read the bill, and I'm gonna take my time and read the bill for you. The bill applies to smoking, vaping, and marijuana, very clearly. The definition of smoking includes that. Secondly, if you go on page 2 of the bill, it requires, there's the word shall. If you go to page 2, line 22, the governing body of the condo association shall develop a smoking policy that is at least stringent as the applicable state and local laws regarding smoking of property in that area. So it's mandatory. It's not permissive. It doesn't empower. It mandates that they must have a smoking policy. And it further states in this bill that under this mandated smoking policy, the locations of where in the condo it's authorized for you to smoke, and the locations of where you cannot smoke in the condo, mandatory. And then if you go to page 3 of the bill, and excuse me for just reading the bill, but if I may just have another moment, Mr. Chairman, if you go to page 3 of the bill, it mandates, it shall mandate that there be a process of filing a complaint against an individual who violates this policy, and it also mandates, the word shall is used on page 2, and it applies here to paragraphs 4 and 5 on lines 3 and 5 on 5. It mandates that there shall be penalties and fines. Mandates it. What are penalties? Is it jail? Is it, I don't know what penalties means. Fines is money. And then the further kicker of this bill on page 3, lines 7 to 13, is that nothing in the bill limits or preempts local government and municipalities from doing something more stringent. So it empowers local and state government to be more stringent than that. Very respectfully, this bill is fraught with problems, and it was killed 7 years in a row in the House and in the Senate, and it's the same bill, and I would urge an unfavorable report.
Senator Love, then Senator McKay.
Thank you.
Thank you, Mr. Chair. As long as we're reading the bill, let's read it correctly.
Yes.
Mr. Bariano?
Yes.
Page 3, line 5. Any penalties or fines for violating the policy. It does not say you must institute penalties or fines. It just says any, if there are any. It doesn't say there must be them.
May I
Please.
all right, please kindly, and I'm very respectful. No, I mean it. Page 2 of the bill, please. Line 26. A policy under subsection C shall state the locations of where you can and where you can't.
And
it
any
shall,
penalties, which means there could be no penalties.
But-
And any penalties. Does not say, and there must be, and there shall be penalties. It does not say, and penalties. It says, and any penalties, which any can include none in statutory construction.
very respectfully,
With all due
I
respect.
don't agree, because on line 4 and page 3, you have the word and, so it's not disjunctive. So the point is, and I'm just reading the bill, the point is, if you're on D, 1, 2, 3, 4, and 5 have to be done. So with the and, not the disjunctive, which is or, which we all know, that means that there has to be adopted in the policy, penalties and fines for violating that policy. And that is mandatory. Respectfully, that's the way I read it, but you are the legislator and I am not.
Thank you, Mr. Chairman. As one of the very few non-attorneys on this committee, can you answer if we pass this bill, and I've been living in this condo association for 20 years, and they determine that we're going to have a no smoking policy, what am I supposed to do? Do I have to sell my place? Does the Attorney General weigh in? How, in any way, does this not open up some form of Pandora's box that I don't know why the AG would want to weigh in on?
You have, respectfully, you have a major problem. You really do. Because, again, assuming condo owners, when they buy a condominium unit, they read the governing documents, which are applicable at that time that they buy it. They also participate, you know, over the years of the condo meetings and all that kind of stuff. If they automatically, and the way I read this bill, if this bill were to pass, the condo association must adopt a policy, okay? Theoretically, yes, it could be a policy of doing nothing. I don't, personally, in my life experiences and my condominium meetings that I've gone to ad nauseum, and I was president of a condo association for 4 years at one time, I don't think if this is passed, it's going to create a lot of conflicts and a lot of problems in the condo associations. They're not going to ignore this. People are going to interpret this that the legislature says you've got to have a no smoking policy. Not only that, but everything else. So, but you have a problem. You either have to move out, sell your unit, or just be miserable. I'm not trying to make a joke. Be miserable. It's the obligation of someone coming into an association to see what are the rules in advance, because they're going to be living in a joint environment. They really are. So there really are those personal obligations. And it was pointed out, condo associations can do this, all of this right now if they want. They don't need this. But what this bill does is force them to do something, to force them. And again, it's not just smoking. It's those that have the ability under the law to do medical marijuana or to vape. And it tells where you can do it on the premises and where you can't do it on the premises. This bill creates enormous problems, and I think that's why, both in the House previously and in this committee previously, the bill has not been favorably considered, because not only because condominium associations can do this authority, they can act now, they don't need this, but secondly, the way this is drafted, it's so rigid, it's going to create a lot of problems.
Thank you.
A lot. It's going to be.
Thank you, Mr. Chairman.
Thank you very much. Appreciate the opportunity.
The testimony in the hearing for Senate Bill 108 will now move on to Senate Bill 150. Senator Watson. Oh, I'm sorry. My apologies. Senator Heddleman. Senate Bill 167. Senator Heddleman, you're up.
Sorry, Senator Watson. You're next. Both alumni at JPR. So.
Good to be back, Mr. Chairman. Is it okay if I bring up my panel? Okay, thank you. Up and loose. Okay, I may have lost one of my. Okay, I'm going to go ahead and start. Thank you, members of JPR. It is nice to be back. My name is Shelley Heddleman. I'm Senator from District 11 in Baltimore County, and I come to you today to present Senate Bill 167, which is a bill that you have heard in years past. I am hoping that this is the year that we can actually get this across the finish line. This bill addresses the problem of SLAP lawsuits. These are, SLAP stands for Strategic Lawsuit Against Public Participation. And a SLAP suit is meant to inhibit free speech. Our founders, in their infinite wisdom, protected in our First Amendment the right to healthy debate and to petition the government for redress. And these are very essential aspects of a healthy democracy. We were out in front in protecting people against SLAPP lawsuits many years ago by enacting a law, and unfortunately, we have fallen behind. I will say that this is not a partisan issue at all. In fact, just last week, the governor of the state of Ohio, Governor Mike DeWine, who is a pretty conservative Republican, signed into law a new SLAPP law. The governor of Maine and the governor of Pennsylvania also recently updated their SLAPP laws. We have slid behind, and in fact, we are given a D by the Public Participation Project, which takes a national look at different states' laws on the books to protect this kind of speech. So I want to talk about a couple, and my panelists will talk about very specific instances about why it's important to update our law to protect our constituents. And these are real incidents, one of which happened this past summer, just a few months ago, and there have been a number around the state. This is not a hypothetical problem. This is not a theoretical issue. These are practical problems that many of our constituents are dealing with. I have here a number of letters, and we had short notice of this hearing, but just in that short time, we reached out to people who were threatened with SLAPP lawsuits just within the last year, and there was one pretty well-known instance in Baltimore City recently. And so we reached out to some of the neighbors who were threatened with a SLAPP lawsuit, and they wrote back to us and said, yes, share our story with the committee so that they know how this affected us. These were just regular people who happened to live in Fells Point in Baltimore City, and a restaurant wanted to do some expansion there and wanted to change wanted to go before the liquor board to change their license. And number of the neighbors got wind of that, as we all have projects like this in our communities, and they were concerned about it. This was going to be a new bar that would have had a large outdoor seating area right next to several residential backyards, and it was being developed by a restaurant group with several bars in the area, and there were frequent noise complaints. This was not a new issue. And so neighbors found out about it. They got their other neighbors and friends to sign a petition, and they were going to go before the liquor board. And the liquor licensing process allows them to organize. And if they got 50% of the immediate neighbors to oppose the transfer of the liquor license, that would be something that could deter this kind of change. And in response, they got a letter from a lawyer, and in fact, I have a copy of the letter that went to the neighbors that was quite threatening to them and said, basically, shut down your opposition or we're going to sue you. And our process now for addressing whether that kind of lawsuit that is meant to stifle and meant to stifle free speech, and again, the opportunity to seek redress from the government, made many of them back down. And some of them did not, and they were able to hire their own law firm at great expense, at great time, at great anxiety, as you can imagine. And our laws were not strong enough to interrupt the process and the cost. And what we're trying to do here is make changes in the law such that we could have certain waylay points where the court could ascertain whether, in fact, this was a SLAPP suit. So what we do is we eliminate, through this bill, is we eliminate in our current law, we have something that requires the plaintiff to demonstrate that they have bad faith in bringing forth the lawsuit. That's a pretty unique provision in our law that is difficult and costly, and it requires extensive discovery and is a problem. The second thing we do is we enable attorney's fees to be shifted, which creates a deterrent to a deep-pocketed plaintiff. The third thing we do is we require the courts to act promptly and hold discovery until there are expeditious rulings. This is not it's not meant to get around the legal process. It is meant to make it more considered and allow an opportunity for a judge to make decisions at certain points of the way and to find if law and in fact it is a SLAPP suit. So it does not serve as a chilling effect to legitimate lawsuits. It allows them to keep going. So I'm going to turn over now to my other panelists to give them the opportunity to share their experiences and provide other insight into why we need this law. But I thank you for your time and attention and happy to answer any questions.
Good afternoon, Tom Cole. While I am a lobbyist here in Annapolis, I don't have a client today. I'm here in my personal capacity. I told you my story last year. I'm going to be brief again. My client wrote a local blog. She commented on a petition effort, a referendum petition, and was sued the very next day. I entered my appearance to represent her in circuit court. I was sued 2 days later. The purpose of the lawsuit, as stated to the court, was to deter criticism of this referendum petition. They were so bold that they would tell the circuit court that the whole reason they brought the lawsuit was to deter speech. I took this case pro bono because it hurts me as an attorney to see our judicial system weaponized to hurt people that are trying to engage in the public process. All of you here have the protection of legislative immunity. Those on the other side of this desk do not. And to engage in public participation, this body has already decided this is a value that we want to protect. We want to protect people's ability to engage in free speech, but it should not come with an asterisk, because having a lawsuit, being sued, comes with its own injury. Many of us have homeowners policies or renter policies that might defend us if we were ever sued in court. My client did not. She faced the prospect of bankruptcy. She faced the prospect of having to pay tens of thousands of dollars for a lawyer in court for a case that may never have resulted in a verdict. When it went to trial, it went on appeal after trial. When it went to trial, the plaintiff said she had no damages. So I would say to you, this law is exactly what we need. We tried to have it dismissed as a SLAPP suit. The court denied that because the law is vague as it's written. This is a good statute. I would ask for a favorable report on this law. Thank you.
Good afternoon, Mr. Chairman and honorable members here of this committee. It's great to be back here in Annapolis. Happy New Year. I am in strong support of this legislation, just as I was last year. My name is Katie O'Malley, and I'm the Executive Director of the Women's Law Center of Maryland. And in my capacity as the Executive Director, I do represent clients. I represent clients in protective order cases, and our attorneys also represent clients who have been sexually assaulted in Title IX cases, and we also represent in custody and divorce. And it's the clients that we represent mostly in the protective order cases and in the Title IX investigations that are the ones that are at risk of this SLAPP litigation. The SLAPP litigation intentionally targets victims of intimate partner violence and sexual assault, as well as journalists, as well as attorneys like Tom Cole, who are representing a client. All different phases of advocacy these suits can go after. And I can just tell you one story that's not related to a sexual assault or domestic violence, but it was about a Kent County teacher who saw on a public Facebook posting a very, very racist comment that was made by a professor at the Naval Academy. This teacher, of course, has no money. She went and made that noticed Facebook public account to the Naval Academy to let them know that this professor was saying these things and was this an appropriate thing. Well, she got hit with a lawsuit that was an intentional infliction of emotional distress, defamation, and she had certainly no funds to do it. But a law firm, a very prominent law firm in Baltimore, took her case pro bono, and it was $800,000 worth of attorney's fees after the jury acquitted this teacher for that suit. So it's just the amount of litigation from a powerful entity that can go on without having this law that we have here in Maryland closely more defined, especially when it comes to that bad faith requiring the defendant to prove bad faith of the plaintiff is very hard, it's very egregious, but also the fact that you're asking the judiciary now to expeditiously make decisions about these suits. So again, the Women's Law Center is thankful to be here today and strongly urges that you pass this bill favorably.
Excellent. Thank you very much. Questions from the committee? Senator West.
I just noticed that at the end of the bill, I hadn't noticed this last year, there are back and forth provisions. If the court grants the anti-SLAPP motion, the court can award attorney's fees. But if the court finds the motion to dismiss is frivolous, the court may award attorney's fees to the other party. So am I right on that? I think I'm reading this correctly. So that if either party to this suit acts frivolously, they can end up on the receiving end of an award of attorney's fees.
Right, that was deliberate so that we can make sure that people are serious about this and
Good.
that they are not acting out of haste.
Exactly.
And that they are acting thoughtfully.
Okay, and I think I'm sure we all agree that deterring frivolous lawsuits is a good thing.
Absolutely.
Thanks.
Thank you.
Thank you, Mr. Chairman. You can hear what's going on in here, and I was right outside having my lunch. So I think Mr. Cole was, are you Mr. Cole?
Yes.
Hi. Could you, if it's in the testimony or in somewhere that I don't have, did you reference your case? I'd like to, read some of the pleadings and.
Yeah.
And it's just, so just, what is that case? Do you
It's
have-
Kim v. Sol Pietro, SOLPIETRO.
And it went up to the appellate level,
Went up to the appellate level. And
all the way up or just intermediate?
just to
Maryland Court of
the,
Appeals.
and unfortunately, it was sent back down, actually, and is pending trial yet again due to a dispute about the pleading standard.
So in that case, again, I couldn't hear every word you said. So your client had a blog. She posted about a development of some sort, and the developer, someone connected, then sued her for.
What? It was not a development. This was about a petition to put a ballot question, a referendum petition.
Okay.
She had written a blog post about that referendum petition, and the chairperson of the ballot committee, whose husband was an attorney, makes her side of things a lot less expensive, brought suit and represented to the court that the purpose of that lawsuit was to deter negative commentary about the ballot referendum.
So that, I will find that in the complaint.
You will.
Do you just, I want to hold this up a little bit because I'll look at it, but do you remember generally what the highlighted counts were? Was it, I'm sure you saw that, you interpret that line as saying that, but the counts were what?
It was very similar to what Judge O'Malley was referencing, where it was intentional infliction of emotional distress, defamation, and false light.
So when it went, so at trial, your client was successful?
Correct.
Okay. Then it went up on appeal?
Yes.
And what was that disposition?
So the disposition, and it was an unreported opinion, but you could still reference it.
Yeah.
Judge Ripken wrote the opinion and determined that because, despite the fact that the circuit court, in response to a motion to dismiss, found that the plaintiff was a public figure for the purpose of defamation law, that nevertheless, that needed to have been repled in the answer. Now,
hyper-technical.
To just keep going on, the answer has now been amended such that that has now been cured, and so we're back to the same spot all over again. And I've stepped away from the case because I'm doing more down in Annapolis now, but my client is now incurring, there's no longer a pro bono attorney on that case. So the injury is real, she is paying money, and it is costing her a great deal of distress.
Many, many years ago, my husband and I were sued, and we responded with an accusation of a SLAPP suit, which was back in the mid-'80s.
Yeah.
So, and I'm still under seal about telling you how that went out there, so, but I was pleased. Anyway, no. What I would like is for, again, my staff is news that and print everything. I would love to get some references to cases, because I can hear you all to explain these or touch on them, but to me, the way I make the most informed decision is to see the parameters of what you claim is the abuse going on now, why our current laws are not meeting that. I have been in the past a little bit reluctant on this bill, not every sentence of it, but maybe some of it. So if I can get some cases, that would, and thank you for answering a few more questions.
Senator, if I may, I would just add, the one that I would recommend to you the most is the decision and memorandum related to the lawsuit brought against me.
You, okay.
Because that was a successful use of the SLAPP law, but it just shows where this party was going and how they were using the judicial system to attack people. And then there was another lawsuit against the Register of Wills for Howard County that was also found to be a SLAPP lawsuit. So the judge, same judge, Judge Karoum, found 2 SLAPP lawsuits and one that wasn't, despite the same tactics being used across all 3.
Because, you know, we learn, we can talk theoretically or talk conceptually, but there's nothing like seeing it in the real world. So that, because I have been reluctant to support this bill, but I do want to read some of these cases because I want to get myself better educated, see if I'm missing a few things and whether there's some common ground. So
there is a lot more balance in this law than there was last year, so I would just
okay, so some differences.
I would say that there are some small differences.
Very good. Thank you, Mr. Chairman.
Whatever you get, would you get it from my office as well?
Absolutely.
Yeah, what you, right, you want it. Yeah, thank you.
Thank you, Mr. Chairman. Senator, so there's 2 unfavorables who have put in testimony. One is this Claudia Barber, and then Maryland Right to Life. And in their unfavorable letter, it says that this bill will create a large legal loophole which will enable large media outlets and others to willfully malign or defame elected officials, nonprofits, and individuals as they've done in the past, but now without legal repercussions. Does anybody from your panel want to address that, or?
I actually have a specific written argument that I could provide to you, but I don't think that is the case. I mean, you're still involving a judge. The judge throughout the process has to make an initial, has to ascertain whether it is indeed a SLAPP lawsuit. So you have protections in the court system process to protect against what they're asserting.
Again, not an attorney, but if we pass this, it sounds like we have the reversal of Goliath versus David.
I'm sorry?
And I don't know, I understand you're shaking your head, Judge, but what can you advise me that why that would not be the reversal of somebody who can go against
Sure, Senator.
corporations?
Yeah, no, this bill doesn't take away anyone's petition to seek redress through the court system, plaintiffs or defendants. There is still, just as Senator Hettleman said, there is still a judge, an arbiter, that is going to look at these suits on their face to determine if there's merit. And the only thing that this bill does, a few things that this bill does that I think is helpful and brings us up to what about 34 other states are doing across the nation, is it, one, eliminates that the defendant in the suit has to prove bad faith on behalf of the plaintiff. That's a very, very difficult burden, very difficult thing to prove, almost impossible. So eliminating that, the defendant in one of these suits has to show bad faith. The other thing it will do is it requires the courts to expeditiously determine whether or not, in fact, this is a SLAPP suit in the preliminary motions, which will cost, if that's not done expeditiously, the attorney's fees can mount up so quickly in this litigation that it's almost prohibitive for the defendant to continue with the case, especially if they're doing it on their own. They call it pro se, if they don't have counsel and they're trying to represent themselves. You know, this is not doing anything other than leveling the playing field, because the plaintiffs in these types of suits oftentimes are very, very powerful, whether it's because they have a lot of money, obviously that creates that power, or because it's a large corporation which would have a lot of money, and they have the resources to continue with that litigation. They don't care how long the suit takes, because it's not going to be a financial burden on them. For the defendant, it does really limit their ability to pursue the case. So it's doing nothing other than leveling the playing field for the parties, and again, keeping the judiciary intact in monitoring the situation. So there's no switching of David and Goliath here. It's basically just letting the parties play on an equal playing field.
Thank you.
Thank you. Judge O'Malley, you just said something which shook me a little bit. You said that this bill eliminates the obligation to prove that the plaintiff brought the case in bad faith. I don't see that language is deleted from the statute. On page 1, it's in ordinary print, and it's not, oh, I'm sorry, it is in brackets.
It is, yeah.
Okay. Well, frankly, that causes me some concern. Would you explain why we want to eliminate from the definition of a SLAPP suit the fact that the suit was brought in bad faith?
So you're requiring the defendant who's been charged to prove that it's been bad faith, and I guess that standard would be, I'm not sure, because it would be a motion. I'm not sure what that standard is. It's a preponderance or clear and convincing evidence. I'm not certain. So it's requiring the defendant show that this is being brought in bad faith. And the defendant, again, in these cases, like say it's that situation with the Naval Academy where you've got this teacher who all she did was report to this military school that one of their professors was posting on a public Facebook post very racist comments, and that it was something that was pursuant to a group that she had belonged in, and there was many posts made by this professor. The only thing this defendant did was provide that information, and then she got sued for an intentional infliction of emotional distress and defamation. How is she supposed to show that it's in bad faith? I mean, all of this can come sort of out through the litigation process, but why would that be an initial burden on the defendant in the case that the plaintiff's bringing, that the defendant prove anything at this point? Quite frankly, they're here just trying to survive the litigation if they don't have counsel.
Well, I was relying on Mr. Cole's description of his case, in which it was pretty clear to me that the suit indeed was brought in bad faith. Because the person almost admitted to him that the whole reason for the suit was to deter him from exercising his First Amendment rights. And that seems to be a pretty open and shut case.
Right.
But I would not want legitimate lawsuits that were not brought in bad faith to be the subject of, to be dismissed. It seems to me bad faith has always been part of the definition of a SLAPP suit. And deleting that from the definition causes me concern. I don't want to have legitimate lawsuits thrown out on the grounds that they constitute SLAPP suits.
Yeah. Senator, this is still retaining the sentiment of bad faith. On page 3, if the plaintiff demonstrates that. Oh, I'm sorry.
Yeah.
Page 3. I apologize. It's at the bottom of the page, line 33. So if the plaintiff can demonstrate that their lawsuit is justified in law and fact, then it is not a SLAPP lawsuit and it will not be dismissed. So rather, how it existed previously, bad faith was a burden of the defendant to demonstrate. Bad faith is still a consideration because bad faith essentially is not having justification in law or fact. But the plaintiff now has the responsibility of saying, yes, this was a matter of public importance. Yes, the defendant was exercising their rights under the Constitution and the Maryland Declaration of Rights, but nevertheless, my lawsuit is justified in law and fact as defamation or false light. And if they're able to do that, the motion to dismiss will be denied. So I would just say bad faith is still center to that consideration. It is near impossible for a defendant to put on affirmative proof of bad faith. And what this does is it's just a burden shift to the plaintiff to say this lawsuit was not brought in bad faith.
All right, so what you're contending is that a suit can not be brought in bad faith, but it may still be a losing lawsuit. At the end of the day, the person's going to lose the case. That's not a slap suit because you're claiming that such a suit could still have substantial justification in law and fact, even though it's not going to prevail at the end of the day, once all the discovery occurs and the trial occurs.
In any defamation, in any action where there is a motion to dismiss, the pleadings are read as if they are true. So the allegations made in the complaint are read as if they are true. The plaintiff will need to demonstrate. So in the case that I was talking about, the actual allegations of the case, if they were held to this standard, that action would have been dismissed. You are assisting the judiciary in deciding how to evaluate a SLAPP lawsuit by providing this additional structure around it. And I would say that line 33 on page 3, we are still retaining, this law would still retain a bad faith consideration, but it would be the plaintiff's demonstration that this lawsuit is justified in law and fact and should be allowed to persist.
But you would agree with me, would you not, that if we pass this bill, we're establishing a lower bar to throw out SLAPP suits? Right now, the bar is you got to show it's in bad faith. So we're going to get rid of the bad faith, and it's a lower standard of you just got to show that it's is without substantial justification in law and fact.
So I would say, Senator, that if you were to look at the legal definition under the case law of what bad faith is, it is the same. It is simply a burden shift.
If that's the case, why are we deleting the words in bad faith?
Because in bad faith, as it exists right now, the defendant in filing the motion must demonstrate bad faith, as opposed to the plaintiff demonstrating substantial justification.
So you're shifting the burden of proof?
Yes.
Okay, it's more complicated than I thought it was. Thank you.
Yes.
Following up on Senator West, I'm so glad you're here. You don't have to answer this today, but you or the panel, please get back to us, following up on what he's saying. Whenever we make a little tweak in the law, we think we get it right. The courts and other lawyers see it differently. So I do not, there is a body of law, long history of what bad faith is, right? Because it's not in some statute, it's not a crime. So what I'm curious about is when we pull that language out, that known, and substitute substantial justification in law and fact, which is sometimes corollary to it, are there bodies of law that address when a litigant has to prove that, number one, and also is the burden still, by my understanding, it's a preponderance, because I don't see you really have to be articulate and precise to say clear and convincing or beyond. Is your understanding this, we're still keeping it preponderance?
Yes, for a motion to dismiss.
Because that makes sense to me. So then the other thing is, and you can address this later, or because there are other states, you said, I don't know if all the other states have done this, and then they have bodies of law, but are there some bodies of law that litigants on both sides and judges can look at to see this difference, and it's well articulated?
So, Senator, one thing that I would suppose in the drafting of this, and I would defer to the Senator and anyone else that advised in drafting of this, is rather than prove a negative, because how it could have been written is say the plaintiff shall prove that the lawsuit was not brought in bad faith.
Well, I understand.
That's proving a negative. So this creates an affirmative, and I would suggest to you that the case law will demonstrate that we're hitting two things from two different angles and ending up in the same place. That substantial justification, because when you get the memorandum orders in the cases that we'll be sending you, I believe what you'll find is that Judge Karoum said, I don't know how to assess bad faith. Like in Mr. Cole's case, I can find bad faith because the attorney threatened him, if you don't withdraw your appearance, I'm going to sue you. I did not have that in the other cases. So the burden shifting, I believe, it would be very helpful and is hitting the intent of the original SLAPP law from a different angle.
I am not disputing that that is what you all are trying to do and you believe in the language, and I'm not, so I'm not even challenging that. I'm just trying to say, can I, because I love to do research and I will, can I go out and find some law in the United States that will guide me in when I'm no longer using the term bad faith, but I'm switched to substantial justification in law, in fact, whether it's in the context of SLAPP suits or elsewhere.
Yes.
Do you think there is some good body of law? Is there some in Maryland too?
Yes.
Okay, very good.
Yes.
Thank you.
No, so actually, in line with what you're saying, actually, I want
Right.
more information on bad faith. So I get the burden shifting. When you read the language, it seems to be in line with good public policy. Like, I feel that, like, it feels right. But bad faith, when absent, like, just a complete black and white example, and maybe Judge O'Malley can, help us on this, but like, how, can you point us in some case law or something that we can kind of look at how bad faith has been interpreted? Because it seems, I mean, I get the public policy justification for removing it, and it reads well. I mean, it feels good, but I'm just not understanding how the courts are interpreting bad faith anyway, and how much, I mean, I know it's a burden, but how much?
Well, I think, Chair, what you would find is that bad faith is very rarely used in the Maryland Code. And I think part of the reason why is why we're struggling with it in the SLAPP context. That substantial justification law, in fact, is actually a more useful term that has more context in the case law than bad faith. Bad faith is, I do not want to suggest that it is a different standard than the absence of justification, but that is how it's often been interpreted. But bad faith also seems to carry with it an affirmative burden of demonstrating either through getting into the head of the plaintiff to say what their motivations were in bringing that action, and that is very difficult to do in the civil context. I don't know if Judge O'Malley had anything to add on bad faith.
No, I agree. That's what I was saying in the very beginning. By getting rid of that, trying to make someone prove what someone else is doing or thinking, is extremely, if not impossible to do. So it might be clear cut because there might be some extrinsic evidence that shows that it was done in bad faith, and those are great cases. You can say, look at this text message I got that, if you go to the police and report this sex offense, I'm going to sue you, and I'm going to, or I'm going to retaliatorily file for something else. And those are great cases, but oftentimes it's just not that clear cut. So like Mr. Cole said, getting the side of the plaintiff's head is almost impossible in many of these cases.
Thank you, Mr. Chair. Yes, so I fully understand that proving bad faith on somebody else's part is really hard. What I would appreciate if you can provide it to me is some case law in Maryland which explains the term has substantial justification in law and fact. I want to see how much of a lower standard that would be than having to prove bad faith on the part of the other party.
Yeah. Yes, that is what I just asked for, Senator West, a few minutes ago. So, but I'm glad we often come to the same point, don't we? Whether we listen to each other or not. But yes, so you know that. This happens sometimes, don't you? Yeah. So I just want to clarify, though, we're going to send us some information, you're going to show us some cases where we can read the language that you are suggesting, but I am going to find cases in Maryland and across the country that speak to what substantial justification in law and fact mean and how a litigant with a preponderance of evidence only standard would meet that. Can you give me an example?
I do not have LexisNexis in my head. I've thankfully run away from litigation for many reasons, this case being one of them. But I will say that substantial justification in law and fact, you will find more cases there than bad faith. And so we will make sure, I will make sure that you get that. But I would also say, and I wish we could poll the judiciary as well, but I would say the SLAPP law as it exists right now it is so ambiguous it is unhelpful, and having more structure there is really what this law is pining at.
Thank you. Thank you, Mr. Chairman.
That's a good conversation. Further questions from the committee? All right, seeing none, thank you all very much. Thank you, Senators. Thank you, Judge. Ms. Cole.
Thank you.
So that'll conclude the testimony for the proponents of the bill. We have one witness signed up in opposition. Mr. Bogley. Welcome. Bogley.
Good afternoon, Chairman Smith and honorable members of the committee. It's good to be back with you again this session. I'm Laura Bogley, Executive Director of Maryland Right to Life. Wow, everything you just heard was really convincing. So if you agreed with what you heard from the proponents, those were all excellent reasons to vote against this bill. And the same reasons why your peers in this committee voted against this bill 6 prior legislative sessions, because they were able to read and understand and respect the intent, the legislative intent of this body, which was to reduce the number of frivolous lawsuits. But this bill, because of the broad loophole language that it has, that classifies several different things as not SLAPP suits, this undermines your legislative intent, the legislative intent of this committee, which has been upheld time over time again. What this does is it creates a huge legal loophole. If you're not familiar with it, on page 2 of the bill, it talks about something is not a SLAPP suit if, and it creates a very broad exception. So your current SLAPP lawsuit already adequately guards against frivolous lawsuits. This will amend that to weaken the legislative intent, to undermine your intention, to allow and expand frivolous lawsuits. Because what it does, Senator Smith, if you're looking on page 2, the paragraph, and I have this in my testimony, it says that a lawsuit is not a SLAPP suit if it is brought in the public interest or on behalf of the general public, and each of the following conditions exist. There's conditions here that don't include whether or not it's commercial speech. So that is very broad. What is brought in the public interest? What is a lawsuit brought in the public interest? So your intention in passing the original underlying statute was to give defendants from frivolous lawsuits an affirmative defense. This bill would deny them that affirmative defense, so we ask for your unfavorable report, and I'm happy to take questions. Thank you.
I'm glad you brought that up because I was out of the room. Let me ask you this. Let's assume we don't care for subsection C either, because that seems to be a lot of extra language that we didn't even focus on in our questioning. So we get rid of C and maybe that whole section. What if the bill were to limit itself to what we just discussed, which is to switch the burden of proof so that the one party doesn't try to get into the mind of the other and prove bad faith, and just make it so that the person or individual that brought the suit, that now the other person's claiming SLAPP, just has to say, hey, it was has a substantial justification in law and fact, and not muddy the waters with all this language about what a SLAPP suit is and is not, which is very untested and very new and seems like a lot more than what we've been focusing on, which is just shifting this burden a little bit.
Yes, Senator James, I think you all asked a lot of good questions about that, and that would just indicate to me that this would need to go back to a work group or some type of study group to really figure out what the implications are, because we've been here year over year and we've rejected this bill, and there's been a lot of discussion about what the standards are across the nation. And this bad faith is the standard that we see in court, bench after bench across the nation.
Do you disagree that they said 34 states have changed this, and the implication, I shouldn't have assumed it, was that they've gotten rid of the bad faith requirement and changed it to the, substantial justification in law and fact. Is that not your understanding?
I think that you asked for case law and you asked for examples, more substantiation of that.
Yeah.
And that's something I think a work group could really look into and to see if it's a good fit for Maryland. The basis of my objection is that this weakens your existing anti-SLAPP lawsuit and denies an affirmative defense to defendants. Why would we make it easier for people with power and money to sue the little guy and not give the little guy this defense? That's the operative language in this bill, is to remove that affirmative defense. And when a defendant says this is a SLAPP suit, guess what? That goes back to the judge. The judge is the one that gets to then be the finder of fact and make that determination about whether it is brought in bad faith.
I'm asking you some questions, so you got to.
And I agree with you that might does not make right. Yes.
You got to stick with me on the questions, but I appreciate, because I want to make sure I make best use of your position. Now I'm going to lose my train of thought here. And I did. So I'm going to let somebody else take a question, because I had one follow-up. You just made a good point, but it was something I needed clarification on. So I will get back to you. All right.
Thank you, Senator.
So further questions from the committee?
Thank you.
Thank you. Almost sounded like you were arguing for the burden shift. Right? All right. I think that's it. All right. With that, that'll conclude the hearing for Senate Bill 167. We'll now move on to Senator Muse, Senate Bill, Senator Watson, are you still here? Yeah. Yes. Senator Watson, Senate Bill 150. My apologies.
Well, good afternoon, everyone. Good afternoon, Mr. Chairman. It's good to see each of you, my colleagues. That's right. I'm delighted to be here today with you. Here to, Senator Watson, for the record, District 23, here to present Senate Bill 150 for your consideration today. This is a bill that was requested by all 24 clerks of the Circuit Court with responsibility for recordation of real property land records in the state of Maryland. The purpose of this bill is not to make any substantive changes in land records, recordations, or requirements. It's merely to update sections of the real property article to reflect current technologies and practices that are already being followed today. The problem is that the law is not kept pace with current systems and procedures, and this bill seeks to bring the statutes up to date. Senate Bill 150 will update reference to outdated language and practices such as requirements for paper books and microfilm records. It replaces those references to outdated tools to allow for modern electronic technology for the submission and recordation of land records. This bill is necessary to clarify the statute, to include what clerks are actually doing in practice versus current law, and is supported by the entire industry. Before the introduction, input on this bill was sought from representatives of the title industry, including the Maryland Land Title Association, Real Estate Bar, and title underwriting companies. Given this bill's full support of all 24 clerks of the Circuit Court and industry professionals, I ask that the committee give a favorable report to this update to land record statutes, including 2 amendments needed to ensure the article's accuracy. If there are any questions, I'd like to turn it over to the clerk of the court from Anne Arundel County, Scott Poyer, who's here to testify in support of the bill and representing the clerks. Thank you, Mr. Chair.
Thank you, Chairman Smith and members of the committee for this opportunity to testify in support of Senate Bill 150. For the record, my name is Scott Poyer. I'm the clerk of the Circuit Court for Anne Arundel County. And I'm also here on behalf of the Maryland Circuit Court Clerks Association, which represents the 24 elected clerks of the Circuit Court in Maryland. The clerks support SB 150 because it updates the real property article in Maryland code to reflect current technology. For instance, SB 150 removes reference to the updating of paper books because land records are now recorded electronically. It removes reference to obsolete technologies such as linen copies, aperture cards, and microfilm. And it removes reference to obsolete practices such as sending paper documents to the Maryland State Archives at the end of the year, because now that the documents are electronic, we send them throughout the year. The clerks had minor amendments to the bill. We discussed with the sponsor. With those amendments, we fully support the bill, and we ask for a favorable report on SB 150. The clerks would also like to thank Senator Watson for sponsoring this bill, and I am available to answer any questions you may have. Thank you, Mr. Chair.
Thank you, Mr. Chair. So the Maryland Land Title Association and the Maryland State Bar Association's real property section both seem to make the same objection, or they suggest the same amendment. And they say that there are standard documents, for example, the standard deed of trust form, which many lawyers use in connection with transfers of title. It doesn't comply with the margin requirements in the bill. And therefore, they would like the bill to be amended so that they would not have to reformat the standard document. What do you have to say to that?
We talked to them this morning, and I talked to all 24 clerks this morning as well. We're not going to object to the proposed amendment, but we haven't had a chance to talk to the sponsor yet, so I would defer to Senator Watson. So we're not going to object to the...
Okay, thank you.
That's fine.
What happened with this bill last session? I'm asking the sponsor.
I didn't sponsor it last session.
You didn't?
Can't tell you.
Okay. Do you know?
Yes, sir. The Senator, we had a larger bill that was withdrawn. We've narrowed down the bill to just the elements that we think are non-controversial. So this is a reduced bill this year.
So it didn't pass out of the House then?
It was withdrawn before it went to committee because there were questions that were coming up. It's a fairly technical bill, and so we've narrowed down the scope of the bill for this year.
I appreciate it. Thank you.
Plus, it got a really.
Yes. Mr. Chair.
Good afternoon, Mr. Chairman, members of the committee. Robert Enton, testifying on behalf of the Maryland Bankers Association. You have the written testimony from the Maryland Land Title Association and from the state, the real property section of the bar. We support those changes. We don't have a problem with the principle of the bill. I think you have to update, many laws, including this one, as products change and everything. The big concern that we have, if you look at the written testimony, at least that I have, I think, is that it says that a clerk may refuse to record an instrument that does not meet the requirements of subparagraph 1 of this paragraph. Now, for any lawyer in the room that's ever handled real estate transactions, and I have, your biggest fear in the world would be that you have a closing, you disperse the funds, and then somebody carries the deed or the deed of trust up to the courthouse, and the clerk says, sorry, we're not going to take it. Meantime, later that afternoon, someone records a judgment against the seller. Now, where are you? Is there a lien now on the property, and you've already closed and dispersed the funds? So I think that's something that we found to be problematic. One of the attorneys at my firm, and maybe Senator West knows him, Ed Levin, who's a very distinguished Baltimore real estate attorney, had some really stylistic changes, and I'll be happy to go over them with the sponsors as well. But I think that's the big concern I have. They also pointed out that they thought that the vendor language should stay in the bill. Those are still deeds of trust that are issued, and that language should change, should stay. Maybe there won't be any more of those, but we don't see any harm in leaving it in. So I think we've always had a great working relationship with the clerks, and I tried to call the clerk this morning and left a message just to raise these concerns, but I'm sure we can work all the language out. Thank you.
Excellent. Thank you very much, Mr. Enda. It seems like the clerks are amenable to at least the first set of amendments, and I don't know about the stylistic changes, but if they're just not substantive, then I don't know. We'll see. But we'll get some folks together and
absolutely
make it work. Okay.
Thank you.
Are we in receipt of those amendments yet?
I'm sorry?
Does the committee have the amendments, the amended language yet?
I think you had the written testimony, and the amendments are included in the written testimony.
We'll get those drafted then.
Great.
Okay, excellent. Thank you very much. All right, with that will conclude the hearing and the testimony for Senate Bill 150. We'll now move on to Senator Muse with Senate Bill 120.
All right, let me make this brief. For the record, Tony Muse, and represent Prince George's County 26th District. Mr. Chair, Vice Chair, and all of the wonderful members. This bill simply adds on something to a bill we passed out last year. I believe it was last year, that would simply establish an objective standard for reviewing and approving solar collector system applications for homes in Maryland. What it now corrects or makes it a little more reasonable is the proposed amendments to current law would establish a specific definition of what being reasonable is, so that you don't have arguments and fights and no limitations in terms of what money, if it's money involved, if it is a matter of the benefits of specific standards like, let's say, for example, if an HOA restricts panels on the front roof of a home, under the proposed amendment, this restriction is deemed unreasonable if the placement elsewhere raises costs by more than 5% or decreases efficiency by more than 10%, and then proof of these impacts must come from a solar design specialist. So all this does is just defines the word reasonable relative to this particular bill that we already passed out. I am pleased to have Ms. Ashley Clark to join me, and so that ends my testimony. I'll stop there, and would you come and do the same? Thank you.
Good afternoon, Chairman Smith and members of the committee. My name again is Ashley Clark. I'm here on behalf of the Maryland Legislative Action Committee of Community Associations Institute, better known as CAI. CAI represents individuals and professionals who reside in and work with community associations such as condominiums, homeowners associations, and cooperatives throughout the state of Maryland. And we want to thank you, Senator Muse, for sponsoring this legislation. Just to echo some of what the senator has said, in relation to the proposed amendments, he talked a little bit about the 5% as well as the 10%. And we're really doing something that our neighbors are doing in Virginia, and that language is going to be mirrored here. By incorporating these specific percentages, both the homeowner and the community association will be able to look to a specific standard when determining whether a cost increase or reduction in efficiency is considered significant, because that's what at issue. The statute does not define what it's considered significant. Without this, homeowners and boards are left to grapple about what is reasonable with respect to those restrictions. Additionally, the proposed amendments will clarify a community association's authority to both install and restrict solar panels on the common areas of the community. The authority to regulate is found in the governing documents for most associations, but this amendment makes it clear that such authority extends to placement and restriction of solar collector systems. Just as a reminder, this bill was passed out of the House the past 2 sessions with no opposition. Last session, this bill was introduced in this committee as well with no opposition. The bill was pre-filed this year in hopes that we can get it to the finish line, so it's for those reasons that we respectfully request the committee give SB 120 a favorable report. Thank you.
Ms. Clark, good to see you. Thank you very much for your testimony. Questions from the committee? They have Guy Gazzone signed up. I know he's the junior. The junior is now with the firm, isn't? That's funny. I was like, what?
I'm not sure.
Wow.
Yeah, it's hilarious. All right. No questions? All right, Senator, Ms. Clark, thank you very much.
Thank you.
With that, that'll end the hearing for Senate Bill 120. We'll now move on to our final bill of the day, Senate Bill 107. Senator Sidnor.
Set. All right, good afternoon. Senator Charles Sidnor presenting Senate Bill 107. This is the bill that this committee passed out of this committee last year, and it passed out of the Senate. We voted 9-2 in favor of this bill. What this bill does, or what this bill is essentially it's an exception to the two-party consent wiretap law that the state of Maryland currently has for purposes of fair housing testing. Many of you know that some years ago we passed the HOME Act. It is the general policy of this state to try to do what it can to limit housing discrimination. Back, I think probably about 25 years ago or so, I used to volunteer for an organization called Baltimore Neighborhoods Incorporated as a fair housing tester. And what one would do as a fair housing tester would go in and you would play act the role of someone looking to rent a property. And the Fair Housing Testing Organization was sending multiple people to see whether or not a landlord was discriminating when they were attempting to rent property out to people. So in my case, I would take on a characteristic. I'd be a black male with certain income, certain age, certain education. The Fair Housing Organization would then send in a white male with the exact same qualifications that I would have. They would continue sending in others until they got a substantial amount of information to determine whether or not discrimination had taken place. What you would do as a fair housing tester is as soon as you did your test, you would go out to your car and start writing down your notes. And you would hand those notes over to the organization. The problem has been that in writing down those notes, when you try to take these cases forward, people don't really want to rely on someone's written affidavits. In most states throughout the union that don't have the law that we have, you're able to actually record those conversations and enter those conversations in as evidence. What this bill does, as I said, is it allows that to happen for a fair housing tester, and solely for fair housing testing. Last year, the committee, we limited the bill to make certain that these recordings could not be used in criminal matters, just squarely for fair housing testing. So that's one of the things that it does. What it also does, it defines what a nonprofit civil rights organization is, because we're not looking for anyone willy-nilly just to go out and start recording. You actually would have had to have been gone through and be participating on behalf of this type of organization. So I'm not going to belabor the point, but we do want to make certain that when one goes onto the market to get a rental, that they're not discriminated against. So I will stand there because you've heard this, I think it's probably this is the third time, right? All right, so thank you.
Mr. Chairman and members of the Judiciary Proceedings Committee, good afternoon. I know it's been a long afternoon. Try to make this very short. My name is Fred Freiberg, and I'm here today to support SB 107, which carves out an exemption for fair housing testers to the all-party consent requirement for recording conversations in Maryland. My written testimony details some of the 49 years of work history and experience that I've had in this field. I've been equipping testers with concealed audio recorders since 1979 and have done thousands of undercover testing investigations all across the United States. As was mentioned, 39 states around the country, it's perfectly legal to do one-party consensual recording. I had the opportunity when I was at the Department of Justice to also conduct investigations in the 11 states that require all-party consent, because the Department of Justice, under the Supremacy Clause of the Constitution, could do testing anywhere in the country and record those tests. So I've had experience all over the country in all kinds of markets. One of the things I can tell you from those investigations is that housing discrimination today is much more subtle than it was in the 1970s when I first started doing this work. You can think of it in terms of the image of housing discrimination being a slam door. It's now much more correct to look at it as a revolving door, where people are politely and courteously escorted in, out of, and away from the desired housing without even knowing they're being discriminated against. And that's why testing is so important. Testing is one of the most effective tools for combating subtle forms of discrimination. Given the more nuanced nature of housing discrimination today, testers need to record their in-person and telephonic conversations with housing providers so that triers of fact who decide the outcome of a case can hear the exact words used by a tester and housing provider during a test. Now, I've attended dozens of fair housing trials where judges or juries heavily relied on the recorded evidence to help them determine whether discriminatory conduct occurred. Recorded evidence enhances our ability to hold violators accountable for their discriminatory conduct, even when subtle discrimination is occurring.
Thank you very much.
Now, I noted one issue in the
very
bill
much.
that I just wanted to quickly mention,
Thank you very much.
then I'll conclude. It seems that
Sorry. Thank you very much. Your time's a little bit over. I'll give you a brief moment to conclude.
Okay, and I certainly welcome any questions.
Yes,
afterwards.
absolutely. No, of course.
Mr. Chairman, members of the committee, Jonathan Smith from the Office of the Attorney General, Chief of the Civil Rights Division. Thank you for having me back again. I had the honor of testifying on this bill last year and in favor of this legislation. Housing discrimination in Maryland remains to be a serious problem, and Senate Bill 107 allows a limited exception to the two-party consent requirement to record conversations for the purpose of testing for fair housing discrimination. In many cases, the recording of a fair housing test will be the best evidence admissible in court that discrimination is occurring and will facilitate effective remediation. Marylanders are protected from discrimination in housing by a myriad of state, local, and federal laws. Effective enforcement is necessary to ensure that these laws are meaningful. For more than 40 years, the United States Supreme Court has allowed evidence of fair housing testing. Testing involves, as you've heard, the use of trained individuals who apply for housing to determine whether there is discrimination. Often this involves matched pairs, persons with similarly situated, except for the tested demographic characteristic. And by this method, they measure whether or not they receive the same information and the same opportunity for housing. Discrimination has become more subtle. Without testing, an applicant or prospective purchaser does not know that they are treated differently than others who do not share their demographic characteristics. It is important to note that SB 107 does not permit wiretapping or the recording of calls for which the tester is not a party. The bill only allows recording if the tester is a party to the call and only for fair housing testing and no other purpose. Testing can be performed, as you've heard, without recording. However, with a recording, the judge or jury can hear directly what was said. Conflicts in testimony can be resolved and lapses in memory avoided. It is the best evidence to enforce our fair housing laws and to protect landlords from misunderstandings or mistaken memories. For these reasons, we urge a favorable report. I got it under 2 minutes.
Thank you, Mr. Chair. Thank you, Senator, for bringing this bill. I want to start off by saying how important the volunteer work that you did and the work that you do is, and thank you for that. And please don't take my question to be in any way not recognizing the importance and validity of that work. Am I correct that housing discrimination suits are civil suits? Okay. As I read the statute, all of the exceptions are criminal suits under our current statute. Child abuse, rape, kidnapping, gambling, bribery, extortion, those are all criminal, correct?
Right. Those are in the wiretapping, the current wiretapping statute, not in the amendments.
Correct.
Yes.
So would this be the first time we are expanding the exceptions to two-party consent to a civil situation?
Yes.
Okay. I have some concerns about that. And again, it's not because this is not important work, because it is. And I understand the need, the desire to have that. But I guess my question is what's next? You know, because there are a lot of other instances where this would be really important and really helpful. And at what point do we stop? Where are we on this slippery slope? So if you could address that, that would be very helpful.
I think there's a couple of ways to think about that. And I'm not sure that making an exception where you have the use of the law for the purposes of trying to end discrimination in housing, which is a serious problem, should be thought of as a slippery slope. This body has the ability to measure under each of the circumstances where an exception is made, whether that's an appropriate use of the exception and the law. And there may be other circumstances. I know that the domestic violence community has come forward with recommendations about eliminating the two-party consent rule in domestic violence or sexual assault cases. This body can take into consideration whether that's an appropriate use or not. Here, what we know is we have a strategy that has been in place for decades now, and is in most states in the country has been effectively used. And we've heard that the United States Department of Justice, currently in Maryland, is able to record and use those tests in judicial proceedings. That without the kinds of problems that people worry about, that this strategy has been used very effectively. And so I would urge, each time someone comes forward and says there's an appropriate use of these exceptions, take those one at a time. And here we have just a decades-long track record where we know that if you can test, what tests are going to take place with or without recording. If you can test and you have recording, that's not only the most efficient way to do it, but it's the most accurate way to do it that protects everybody, that this is an appropriate exception to be able to make. So I would urge not to think of this as a slippery slope, but one exception, and then each time someone comes forward and says we need another exception, judge that against the record of how that exception has been used in other places. And we have a very long record here in 39 other states and all 50 states by the Department of Justice of using recording without the creation of the kinds of problems that one might be concerned about.
Thank you, Mr. Chair.
Thank you, Mr. Chair. With respect to Senator Love's question, tomorrow I'm going to present a bill that has 2 more civil exceptions to this rule. So it's a relevant question. It's a relevant question which we'll have an opportunity to further explore tomorrow afternoon. And to my question actually was to Mr. Farberg. Were you about to suggest an amendment that you wanted to this bill when your time ran out?
I just had one more sentence I was going to give you, and that was that I noted in the legislation that it mentioned oral communications, and obviously in testing, testers who pose as prospective renters and buyers have phone conversations as well. Sometimes they talk to agents over intercoms. Those are technically electronic communications. So I wanted to make sure we didn't exclude those kind of communications from being able to record them, because it would be very strange for a case to go to court on fair housing and only the in-person visits are recorded, but not the related telephone conversations and other kinds of communications. So I didn't know whether that needed to be an amendment or clarification of the bill as it's stated, but right now it says exclusively oral communication, and I thought it should encompass both.
Yeah. Senator Sidner, I'm sure, will take a look at the bill in light of your comment. Thank you.
Thank you, Mr. Chairman. So in these, it'll probably be for you, Senator, in the testers and the extensive education that they have to go through to become a tester, that kind of stuff, how do we assure that protections for private conversations that make it onto a tape don't get brought up somewhere else? Or how do things get redacted? You know, if it has nothing to do with it, but it's a conversation that is just, you know, who knows what it is, but.
Actually, technical, I may not be able to, you might be better able to respond. One of you.
Well, I can perhaps answer that by simply saying that we've had cases, of course, where testers have been, let's say, in an apartment building or real estate office, and other people enter the situation and participate in maybe a side conversation or something. When these cases go to court, those conversations do not become the central focus of anything. They're not even usually transcribed. They're like considered background noise and so forth. So they don't get revealed in the cases, in my experience. It also happens very seldom. It only happens in a few rare occasions where that side conversation occurs. It's usually been pretty meaningless and irrelevant to the matter at hand, but it's possible because you're in, it's like going into a Kmart and talking to the clerk. Other people can approach you, other people can overhear the conversation. It's hard not to have that noise sort of come into play on a recording, so it can sometimes occur.
So I'm drilling down, I'm not looking at the management companies, I'm not looking at the large corporations, I'm looking at the small landlord.
Sure.
You got a elderly gentleman who doesn't get to see a lot of people and learn, and for whatever reason is blabbling off about, I don't know, X, Y, Z. How do we make sure that those type of private conversations don't get into some form of a record that can be used against that person in the future for some reason? I don't know the answer to that.
Well, it's a smaller housing provider. If they're actually offering some property on the market to rent out or to sell, those conversations could be recorded by a tester.
Right, but and I understand that. But your smaller landlords, those who are just, it's a hobby of doing this, it doesn't mean that they just should discriminate. So I'm not trying to eliminate them from being part of the test. But I would think that those anecdotal stories may come up in a small-time landlord compared to somebody who's a management company that I'm here to check these boxes and do such.
So on page 3, lines 30, 31, and page 4, lines 1 and 2, the contents of the intercepted oral communication that's made is limited only for the purpose of enforcing federal, state, or local fair housing laws. So I would assume that if Joe Schmo, little landlord, is talking about something that is not relevant to the fair housing test, and it wouldn't be relevant, so there would be no need to enter that into testimony.
Okay, I think I understand where you're coming from, but I use a good example, our lead laws. For whatever reason, they make some kind of a comment that said, I just went ahead and I've registered, but now I'm just doing the testing on it.
Yeah, not relevant to the fair housing, that wouldn't be relevant.
Okay. Thank you.
Thank you.
Just one thing we'll have to explore, just tacking on to Senator Love's question, because we started looking this up in the statute, because the exceptions are for criminal, but also for law enforcement or people acting under their direction. And then the other exception applies to like communications, like emergency communications, government emergency communication centers. So just, we have to have a good conversation about the qualifications and the training for these nonprofit entities. I think that's a good question. It's a good discussion to have.
Well, and this gentleman right here, he helped with that. So you're talking about standards that HUD has put together. Would you want to elaborate?
Sure.
Not to belabor this.
Most of the training manuals used to train testers around the country I wrote, and they've copied various things I've done around the country. I also developed the training program for the Department of Justice employees that do testing. So I'm very familiar with how training occurs and so forth, and it's always done under the strict supervision of a test coordinator. So there is a person who is essentially an investigator who is pulling the strings, issuing assignments, writing detailed characteristics for the testers, and then they go out and perform what they're supposed to do vis-a-vis the instructions that were given to them, following the general guidelines they were trained in. So there's a training manual online with the organization I work for presently. A number of organizations make their tester training manual available as well. It's a solid program that has worked, and one of the reasons we know it's worked is that courts around the country have affirmed that this evidence is credible and admissible in court, and that it, there haven't been significant issues in the 50-some years since the Fair Housing Act was initially passed.
Thank you. Thank you, Mr. Chairman. And I apologize, John, I had to step out, take care of something. There's always an emergency, as you know, Senator. So if this was asked and answered or discussed, then I'll just tell me where to read it. Either one of you, I don't know yet. So you, this is a program with a lot of good training, and you are apparently one of the well-tested, well-respected experts in this area. Where does the funding come for this? And generally, where does it exist? We will be opening up Maryland, the whole statewide, for the first time if we pass this. I think following up a little bit on Senator West, you know, we have landlords everywhere, but we have very big metropolitan areas in Baltimore, Prince George's, Montgomery. Then you sort of step down to Anne Arundel, well, Baltimore County, I don't know. You keep going down, and then suddenly you come to Hartford, my smaller county, Cecil. Then you go out to the shore in Western Maryland. Give me a sense of, once we let a program like this in, and obviously it sounds like we want to go after, you know, big bad actors that have a lot of property and a lot of influence with their negative behavior or positive behavior. But in reality, when a program like this comes to a state, eventually does it permeate, and so we have testers everywhere and they're going after, I'm a landlord and I'm such a mom and pop landlord, it's funny. So, and then of course you've got all kinds of other people that might be relying on it for just some supplemental income in their 70s. Give me a sense of when this program opens up in a state, what should we expect over the next couple of decades in terms of how it rolls out and where it will be and what its targets are?
Okay, the statute as written right now suggests that the testers work with either government enforcement agencies, and right now I'm not aware that any have testing programs presently. Whether that would change, I don't know.
Is that state, not federal?
Well, it could be state, local. Federal doesn't matter because the federal government can test and record everywhere in the country.
I see, okay.
But state and local agencies that I'm familiar with in Maryland do not currently have testing programs. Whether they would start one, I don't know.
Okay.
The other reference is to qualified fair housing organizations, and that's a term of art. That actually is a definition that HUD has provided for a major funding program that funds many of the fair housing organizations around the country that do testing. So that's a finite number of groups. Okay. Right now, there is no group per se located in Maryland that is a full-service fair housing group funded that's considered a qualified fair housing group. The Equal Rights Center, which is based in Washington, D.C., does cover Maryland or parts of Maryland. And so I know they have some jurisdiction, but they've been testing right along anyway. They just have not had the ability to use recorders as they have in the district and in Virginia. Mm-hmm. So you know, I don't know exactly what the full scope of changes might be. I can't predict the future, but I think one of the things that's inhibited a fair housing group from forming in Baltimore, because there's such grave need in Baltimore for some kind of anti-housing discrimination program, is the fact that this recording law has prohibited groups from using recorders in their testing program. And in my experience and the experience of many groups in the 39 other states that can record, is that makes a big difference. And it could be encouraging to a group to get formed in order to do more testing and enforce fair housing laws more vigorously, which would be a good thing in my view.
Well, to follow up, sir, how long have you been, and I'm only asking this as a pref to another question, but you've been in this for 20 years, 30 years, 40 years?
49 years.
So
I'm new.
That's right. So because of that, is it fair for me to assume that you have seen states that have adopted this kind of legislation and how it rolls out over decades?
That part you did miss. 39 states in the country actually have one-party consent laws. So it's perfectly legal for a tester to record anyone they have contact with and so forth. So the majority of the country, you can do one-party consensual recording. There are 11 states right now, Maryland being one of them, where you cannot.
So my question was because you've been in the world of helping with testing and testers, and in those 39 states, I assume some of them have always had this or it goes back decades. I'm just trying to get your knowledge of how it might play out in Maryland. You want to know what I think? And I could be so wrong. It'll start and concentrate primarily in Baltimore where there's the greatest need. Right. Then it will probably go to larger jurisdictions. Could be Prince George's, Montgomery, could be Baltimore. And then if it's going to go beyond that, what I'm trying to get to, does it go out to the little counties and the far-flung places? Has that been your experience? Is that been what you see in other states?
The one restraint on the proliferation of testing organizations and testers is the fact that funding is very limited.
That's
There's
why I asked
one
about
federal
money.
program that provides direct funding to fair housing groups, and that's about it. Most foundations don't fund fair housing testing. There's now, I've gotten New York State to now agree to fund the fair housing groups in New York State, but that's rare. In fact, I think it's the only state in the country where the state government is actually making it a line item in their budget in the future.
And they don't have a deficit right now. They might, though.
Well, I don't know what kind of deficit they have right now, but that I think is the biggest restraint toward proliferation of groups cropping up and starting to do testing.
That's helpful to me. Thank you, Mr. Chairman.
If I may, one of the things that you did, Ms. Senator, I was a volunteer for an organization called Baltimore Neighborhoods Incorporated. That organization was dissolved a number of years ago, but was it? What's your organization? Is Economic Action Maryland. I always want to call it Maryland Consumer Rights Coalition, but they seceded that organization. So testing takes place in Maryland. What this bill is solely about is how one gathers the information, the evidence.
So you used to do it.
I did, and you would go and, as I had mentioned, I would do whatever I did, go back to my car, write down fill out my form that I was told to fill out, deliver it to the organization. This eliminates the need for doing that because I can take my cell phone and just kind of have it in my pocket recording while I'm having that conversation. So that's what makes, that's the newness of this, nothing else. Everything else is currently going on.
Thank you both.
Thank you.
Oh, thank you.
All right, thank you very much, Senator.
Thank you.
Good afternoon, Mr. Chairman, members of the committee. Aaron Greenfield here on behalf of the Maryland Multi-Housing Association in opposition to Senate Bill 107. You have our written testimony. I'm joined today by Jim Johnson, the former Baltimore County Police Chief, who is here if the chairman allows for any technical questions that I'm unable to answer. While combating housing discrimination is a necessary goal, this bill raises serious concerns about privacy, accountability, and the potential for abuse. By targeting housing providers, this bill undermines the fundamental privacy rights guaranteed by two-party consent laws. This bill isn't as simple as the sponsor makes it out to be. This is a question of whether you're going to open up your wiretap statute, create a civil exception for the first time, as Senator Love indicated. Who is next? What precedent are we setting? Bankers, journalists, elected officials? Come to think of it, housing providers wouldn't mind intercepting some communication from code enforcement officials. Maybe we'll come in with a bill on that next session. In fact, in California, and just in 2023, a two-party consent state, the state considered similar legislation before the sponsor withdrew the bill. This bill lacks sufficient oversight mechanisms to prevent abuse by individuals or organizations conducting these fair housing tests. Without clear guidelines on how and when such recordings can be made, there is a significant risk that individuals might misuse this authority. And we still think this bill is silent on qualifications and trainings for those nonprofit entities that would be authorized to do this testing. As you heard from the proponents, fair housing violations can be documented through non-intrusive methods such as written communications, publicly accessible information, or direct observation. These methods actually respect the privacy of all parties, and for these reasons, we respectfully request an unfavorable report.
Thank you for your testimony. Of course, what you say, that makes me want to ask what the sponsor has to say, but I can talk to him later, and you maybe not so much. I've always been reluctant to open up this process to, no matter how good the stated goal is. But you said something, and I think if you can back it up later, that might be helpful. You know, the slippery slope argument. So we open it up for this very worthy goal. But whenever we do anything, it is inevitable that another group will come in with another worthy goal. We've got to get corruption out of politics. We got to get government officials that are, you know, being scofflaws or indifferent. And it goes on and on. But what I don't know is when you happen to say that, like there's that risk, do you have anything to back it up? Have other states that have not had this consent tended to proliferate all kinds of other mischievous uses of this that would really might bother quite a lot of us morally, ethically, or otherwise?
Well, Senator, it's a great question. I don't have that information in front of me. I do know that there are variations in the states that have one-party consent with very, multiple, exceptions, but I can look into that further and get back to you.
Yes, and then if you also made another point, and I asked the sponsor to tell me about it later. You mentioned some flaws in the bill. I don't know if they are or not, but lacking guardrails. We have 39 states that have, one-party consent, or whatever you want to call it. So I don't know if, again, you have in mind some lacking guardrails or in this bill that you saw well addressed in other states. So just another thought of how you could be helpful to people like me and the rest of the committee.
Sure. I mean, and one of the gaps in this bill is there is no sort of, authority like you would have in the criminal realm where you'd have a judge signing off on a warrant, right? You don't have, this is sort of an automatic interception. There's no screen, there's no filter. And I think that's one of the problems we have.
I hear you, but I don't know if in other states, for example, I mean, maybe it's too onerous. Well, of course, everyone would argue that, but maybe in other states, it's best practices that you go to court and you say, show some compelling evidence. We have a jurisdiction. Don't mean to pick on Baltimore, but we'll just use it because it's so large. Jurisdiction, we have pretty good evidence that there are at least a dozen or more landlords that are systematically making it challenging. We think there could be some real illegality or, failure to court says, okay, I think you've established enough probable cause. It's not criminal, but probable cause or whatever. And now I'm going to go ahead and allow you to do this with some guardrails and oversight. That to me sounds like very good balance, but I don't know how this works and I don't know if other states do that, but you bring up a good point about it being almost self-automated. Then how do we keep the accountability? And you can look to other states, but it's always best for us to decide we will make sure we do the best practices we can. So if you have any information later on about that you want to just send me to read, that'd be fine.
Will do. Thank you.
All right. Thank you.
Thank you very much. Mr. Greenfield, when I look through MHA's testimony, you make it pretty scary. You talk about the risk of abuse and overreach. I'm curious, Maryland Multi-Housing Association, I'm assuming all of your members are from Maryland, so you don't have any members who may operate in other states. Am I correct?
We have, our members are based in Maryland, but we have members who do operate in other states if they're larger, professionally managed entities.
Do they operate in DC or Virginia?
Sure.
And where this type of activity is legal? Has it led to your clientele talking about overreach and the abuses and the chilling effects of legitimate communications in those areas where your clientele operates outside of Maryland?
I don't have an answer for you, but what I can tell you is that, this is the first time, again, that you're opening up this statute in a civil way without very specific safeguards in the bill. So what happens in D.C. where it might be a one-party consent location.
Which safeguards would you need?
Well, I think there needs to be very specific training elements in the bill.
You get all that. We just had someone up here who testified who put together the training for the Department of Justice and uses that as a basis for the training that's done by your nonprofits who are going to be sending out testers into the world to ensure that people aren't being discriminated against.
This bill
we talk about potential for entrapment and unfair practices. Has that happened to any of your clientele?
Can you repeat that? I couldn't hear you.
Entrapment and unfair practices.
It is a possibility.
But has that happened in reality?
And I'm not aware. I haven't spoken to members about
the increased litigation and legal challenges. maybe, because you'll now have the ability to have a jury or a judge believe the cases that you're bringing forth. And I know because organizations don't have this, they tend not to bring cases because of the possibility of them losing. I mean, bringing forth litigation costs money. Alternative methods for enforcement, which is doing what I did, which is just kind of writing down your affidavit, and that's proven not to be as effective as it is recording. This, you mentioned the negative public perception. It says permitting secret recordings by individuals acting on behalf of government or nonprofit programs risk generating negative public perception. This may undermine support for fair housing. Could you elaborate on that for me?
Well, if you open this up again and create a civil exception where no other civil exception exists in statute, and you start this practice where, again, the bill is silent as to training and qualifications, and you open this up, we don't know what's next. We don't know if that person is trained. We don't know. They
have to be trained.
It doesn't say it in the bill, Senator. It says it doesn't say what the training is.
Give me just a moment. So a qualified fair housing enforcement organization or fair housing organizations is defined within the Code of Federal Regulations. If you look there, you'll see a number of the things that the marks that these organizations who are qualified to do this have to hit. And that's a standard, right?
I think it's a very weak standard if you even allege it's a standard.
It's a weak standard?
Yeah.
Okay.
You take a complaint, you investigate the complaint.
But I'm still trying to understand this negative public perception.
Well, there's going to be a natural distrust by housing providers if they believe that any nonprofit civil rights organization or any nonprofit can just start making calls and start taping them, intercepting their communications, whatever the term of art is, without there being some filter, some screen by which someone is indicating, oh, look, there's some evidence that this does in fact happen. Look, the Maryland
They're involved
multi-housing.
in a commercial transaction, though, right? It's not like we're going, like the fair housing tester is going and having a private conversations. They're involved in commerce.
Right.
You don't think, so commercial transactions you believe should be given the same rights of privacy as private communications?
I think we should be abiding by the standards in our two-party consent law.
Thank you. That's enough said.
All right, further questions from the committee? Seeing none, thank you very much, Ms. Greenfield. All right, with that, that'll conclude the testimony in the hearing for Senate Bill 107 and our hearings for the day. We have how many bills tomorrow? 10? We have 10 bills tomorrow after session. Most of them are re-entries, so see you tomorrow on the floor. Have a good one.